Ya Allah, Ya Allah, si sebenza ko Ya Allah. La ilaha illallah, Muhammadur Rasulullah. La ilaha illallah.
Assalamualaikum everyone. I would also like to thank Ikram Hussain and Mufti Abrar and everyone else who's involved with setting this up, and especially Mufti Abrar for leading into what I'm going to talk about in the second half of the session. Now, before Isha, we had talked about what Mufti Abrar set up was what does Sharia require of us when we die. There are a lot of things that it requires of us regarding our will, regarding how we behave, regarding who has rights over us. And so now we have established that we know what we should be doing, what is required of us by Allah and by Sharia. The problem is that we live here in this country, and in this country, Sharia is not default. What that means is that here in the state of Illinois, or in most states in the United States, all the states in the United States actually, you can do what you want. You have your money, it's yours. You can do whatever you want with it. During your life and at death, the only limitations are that you can't do something illegal or you can't do something immoral. So just explaining what that means. Illegal, you can't say in your will, I will give you $1,000 if you go kill someone. You can't obviously do that. Also, you can't do something that's immoral. What that means would be, for example, I will give you $10,000 if you divorce your wife. You can't say that in a will. You can't encourage divorce. You can't say, I'll give you such money if you start drinking or if you go gambling. You can't do that. You can't do immoral things like that. But short of that, you can do what you want. If you want to do Sharia, you may do Sharia. If you don't want to do Sharia, there's nothing in this country that says you have to because you're Muslim. If you want to take everything and give it to one child and not another child, legally you're allowed to do that. If you want to take everything and give it to charity, you're allowed to do that. If you want to take everything and give it to your dog, you're allowed to do that. In this country, you're allowed to do that. The only caveat, the only requirement is that you have to write it down. It must be in writing. There is no way and no excuse to get around that. You cannot have a will, you cannot distribute your assets upon your death if it is not in writing. And this is a lot of problem that people have. When somebody comes, and a lot of people ask, okay, well, if I downloaded something off the internet, there's the ICNA will, you go to Office Max and you buy a will, and they say, okay, well, I downloaded that and I have that, is that good enough? My answer is, as an attorney, obviously, I'm gonna say, you know what, you might not have that and everything, but my answer usually is no, it's not good enough, because you don't know what the requirements are. I can't tell you how many times people have downloaded something from the internet, whether it be an ICNA will or something else, they filled it out, they signed it, they were happy, they thought they made a will, and they were very satisfied with themselves, but they didn't have any witnesses, and so that's not a will, it's a piece of paper. If you have a will, if you thought you wrote a will and you signed it at the bottom, and if you did not have two witnesses, that's not a will. That is not a will, it'll get thrown out of court, whatever you did was for nothing. So it's very important to follow the procedures that this country has, that this state has, that says if you want to write a will, there's a way to write a will. It has to have certain statements. It has to have something at the beginning, it has to have certain wording at the end, it has to have certain signatures in certain places, it has to be signed, dated, timed. It has to be done the proper way, otherwise it's not a will. It's a nice try, but it's not a will. So that's very, very important, and I'm emphasizing this because people don't understand. They think like, okay, well, I just get it and it's okay. It's not okay. Or my family will take care of it. That's no guarantee that they're going to take care of it. Okay? You have to do it. You have to do it the right way. You have to prepare because you can't rely on other people to do it and prepare for you. What happens if you don't have a will? So, like I said, Mufti Abrar established what we should be doing. Now I'm going to tell you what will happen if you don't do what you're supposed to do in this country. First of all, if you don't do anything, you get hit with the maximum taxes and the maximum costs that the state and the country can collect. That's obvious. There are ways to get around everything. If you don't want to pay taxes, there are ways to get around paying taxes that are legal. You can create tax shelters, you can create exemptions and take advantage of the exemptions that you already have. You can do all of that. You can get around going to court, get around probate, get around paying fees, get around a lot of filing fees, get around bond. There's ways to get around everything. but you have to know what you need to get around and how to get around it. But if you don't have anything, you're going to be paying the maximum of whatever you can pay. Off that maximum, obviously, Sharia will not be implemented. What you have is most likely not going to, right now, what most people own is not compliant with how they should pass stuff when they pass away if they want Sharia. So what will happen is that if you pass away, whatever is in joint tenancy will automatically go to the survivor. So if you're housing your bank accounts and etc., that'll automatically go to your wife or your kids or whoever. And whatever is not, or if your wife is or your spouse has already passed away, then it will be divided 1/2 to your spouse and the remainder to your children if you have children. If you don't have children, everything goes to the spouse. Obviously, this is not consistent with Sharia. Either on the death of the first or the second spouse. If you're saying spouse only gets half and the children get the rest, that's not Sharia. Spouse takes all, if you don't have children, that's not Sharia either. The important thing you have to realize is that Allah has given people rights, and once you pass away, that right goes to your heirs. Now, if you fail to fulfill their rights, that's a liability on you, it's your fault. You're going to be accountable for that. But it's their right, because it's their right to receive it. So, now we've talked about what should happen. Now let's try to build, we talked about what should happen according to Sharia. We talked about what is going to happen if you don't do it. Now we talk about the bridge. Okay, now we're going to try to talk about how to go from where we are now, which is not Sharia compliant, to where we want to be, which is doing according to Sharia, and what instruments and what issues and what is it that we need to think about and worry about, and how to think and worry about them in order to make sure that what we want is going to be applied when we want it, when we pass away. In doing that, there are 6 issues. The first issue is what most people think about when they think about wills. When you say, okay, we're going to talk about wills, everyone thought, okay, what are we going to talk about? We're going to talk about who gets it and how much are they going to get. That's what most people think about, and that's the first 2 parts of the first issue, and there's 5 more issues after this. These are the 2 easy questions. These are the 2 easiest questions that you can answer for the will's distribution. Is who will receive, because, as Mufti Abrar talked about, that is made up. That is set aside. That is set down in the Quran. This is how much you get. Now, most people don't have complicated situations. They have a spouse, they have children, sometimes they have parents who are still living. That's the most complicated. The most complicated I've seen is that either the person didn't have any children and their spouse passed away, so their siblings inherit, or they were married, they had some children, and then they got divorced and married again, and they had children with a second spouse. So that's the most complicated situations I've ever seen people. Most times you're not going to get in a situation where you have to determine, okay, well, how much does my half-brother, how does my half-uncle on my mother's side get, and how much does my paternal grandfather's sister? No, that's not an issue for most people. Some people have that issue, but most people don't. It's very simple. Who receives it? It's in the Quran. How much will they receive? That's in the Quran. The portions, the fractions are set aside in the Quran. That is very easy to determine. The next questions become hard. Next question is, how will they receive it? How will they receive it is very important when you look at the way most people in this country hold property. Most people have house and bank accounts. When you have a house and you have a bank account, most people have it jointly with their husband, the husband and the wife, have it jointly in the bank accounts and the house. Both things are on the title of the house, both things are on the bank account. Everyone does that. What that means in the United States is that if you have an asset that's joint like that, both parties own 100% of that asset. I have a house. It's my name, my wife's name. I own 100% of the house. She owns 100% of the house. What that means is that if I die, she still owns 100% of the house. That house is hers. Bank account. Both our names are on the account. If I own 100, she owns 100. One of us, if I die, she still owns 100. She can go to the bank and take all of it. Just like in life, she can go to the bank and take all. If I die, she can go to the bank and take all. Now, the problem with this is that Sharia does not recognize this type of ownership. 2 people cannot own 100% of the same property under Sharia. You have to have percentages. It has to be 50-50, 40-60, 90-10, some percentage, but 2 people cannot own 100 of one object. Okay? that's good. So now that's a problem. Because if you pass away, 100% of the house is going to your wife. Where Sharia does not only does the Sharia does not allow that, but maybe that's not even what you intended. Maybe her name was on it, but you were putting all the money, you put all the mortgage, you like paid everything. So it's actually 100-0. Or maybe it's 90-10. Or maybe it is 50-50. Or maybe it's her house, that's 90, and you just live in it, and it's your time. Or something like that. So you have to be careful, and we have to know that if she receives 100% of the house, that's how she received it, but she's not entitled to 100% of the estate. She's entitled to a portion, not all of it. So maybe she's getting more than what she receives, or what she should receive. Same with a bank account. If you have her assets, everything is joint, and everything goes to your wife, now that's going to be unjust to your other heirs, your children and your parents, because everything is 100% is going to the wife, where she was only allotted 12%, 12.5%, or something like that. So that's a big important issue. When you talk about how people receive it, that most of us own assets in a way that when we die, our inheritors will inherit it in a way that may mess with the Sharia. The next issue is when they receive it. And this is an important issue when you're dealing with 401ks and IRAs. If you have a 401k and an IRA, that's obviously not going to mature until you reach 65 or 64 and a half or 59 and a half, however the account is set up. If you pass away before that age and you roll that over to your spouse or to your children, first you have the issue of when. If everything is going to your spouse, then maybe she's getting a larger share than what she is allowed to under Sharia, but also when she's getting it. Now, if she's getting the share now, but she can't collect on it for another 10 years, how much has she actually received? And what can she do with it? And is it okay that she receives it 10, 15 years, maybe 20 years later, even though she's inheriting it now? Okay, and what if she wants to take it out and you have to pay the penalties? That can be up to 50, 60% if you close an IRA or 401k early. So these are important questions. And when you're talking about when, and you want to make sure the Sharia is applied, is the Sharia being applied in how you are distributing your asset? The final issue is what do they receive? Now, when we distribute assets, we are distributing in a whole. We're not distributing 1/3 of the couch, and 1/3 of the bank account, and 1/3 of the house, and 1/3 of the jacket, and 1/3 of the... We're not doing that. We're taking everything together, all the values together, and we're saying you get 1/3 of everything, you get 1/3 of everything. So you can arrange it to say, okay, I get the house, my wife gets the entire house, but all the bank accounts go to my son, and all the 401k goes to my other son, and all, something else goes to my mother. You have to arrange that. And so you have to look at what is it that people are going to inherit. Also important on here is if you want something to go to something in particular, you have to specify that. This is very important usually with the sisters who have a lot of jewelry. And they say, I want this jewelry set to go to this daughter, and this jewelry set to go to this daughter-in-law, and things like that. It's very important. When you want to divide it up, and you say, first of all, it's going to decrease fights. And second, you know that, okay, well, this is how I have it, this is how I'm going to arrange it, so you get this, you get this, you get this, and everything will be properly distributed, and it's not going to be an issue. There's not going to be conflict between your heirs or between the Sharia and your assets. The second issue, which is very, very important, especially in this country, is guardianship for children. The only people who are allowed to take care of minor children, minor means under the age of 18, are the mother and the father. If the mother and the father have both passed away, no one else has the right to take care of them. It goes to the court to decide. Grandparents, aunts and uncles, older siblings who are over the age of 18 do not have a right to take care. The court decides who takes care of them. You have the right to decide first before that. You can say, I want my brother. If my brother can't do it, I want my sister. If my sister can't do it, I want my other brother. You can spell it out and the court will listen to you. The court has to listen unless, if my brother's in jail or gone or something like that, they're not going to do it. But if you spell it out, the court has to listen. If you don't spell it out, the court's going to decide based on its prerogative and what it deems as important. And what obviously the court deems as important is different than what you're going to deem as important. Because maybe you'll deem that, okay, what's most important is Sharia, or not Sharia, but like they'd be raised by a Muslim family, they'd be raised Muslim, they would be raised by family members, they'd be raised in the community. Those are issues that are important to us. Court looks at issues like the adjustability, the financial stability, how far away from like where the child grew up is the child going to move. The courts will prefer to put a child in a foster house, in a foster care in DuPage County than send it to a family in Wisconsin. Okay, the courts have their decisions on what's important. Best case scenario, if you don't have guardianship written down, is that some family member will come in and say, okay, I am the uncle, I am the cousin, I'm the brother, I'm something, I want to take care of the child. The court will say, okay, that's noble, you want to take care of the child. Are you financially capable to take care of the child? What's your income like? How much disposable income you have? This is how much the child costs. Can you handle that? Do you have a house? Do you have space in the house for more child? If you are married and you have 3 kids and your brother passed away and he has 3 kids, are you going to be able to raise 6 kids? Is your wife going to be happy raising 6 kids? Like, these are the issues the court is going to ask. These are issues that you should also ask yourself and your family, that when you're assigning somebody to be a guardian, is this something that's going to happen? And that's really important. It's important. You have to ask and answer these questions, otherwise the court is going to. And the way the court answers your question is going to be different. Next issue is taxes. There is a tax to die. Right? For the next 2 years, the tax is between 17 and 33% of assets over $5 million. That means that if your assets are more than $5 million, you're going to pay a tax. If it's less than $5 million, you don't pay a tax. If you have more than $5 million, there's tax shelters and there's credits and everything that you can do. I don't want to get too much into it on what it is and how to avoid it and how it's structured and everything, but it's just something to think about, that when we are dealing with creating the bridge, we're creating a structure to apply Sharia, it doesn't mean that we have to give all the taxes. We have to it doesn't mean that we can't avoid and we can't think about this country and how to get out of paying taxes and the fees and everything in this country also. So if we have this issue, then we want to talk about it. I wanted to bring it up as it's an important issue, but not necessarily relevant to everybody. This next issue is actually relevant to everybody. It's probate courts. What probate courts means is when we talked about, okay, you have assets. The courts are going to oversee how you distribute your assets to your heirs. Why? Because, for example, if I have a bank account, I pass away, my wife can't go to the bank and take it because her name's not on the account. The bank's going to ask, okay, well, I want a court order to do it because the bank doesn't know my wife. They don't know if she's lying. They don't know if you got divorced. They don't know any of that. So there is a court process to taking care of everything and distributing it, and that is called a probate process. What happens in probate, and I'm going to elaborate a little bit on what Mufti Abrar talked about on what happens when you die, how your assets distributed. Now, Mufti Abrar mentioned, under Sharia, first thing that you do is pay for your funeral expenses. Illinois law requires the same thing. First thing you do, 1.1 is funeral expenses. 1.2, right along with the funeral expenses at the same level of importance under Illinois law, is you have to pay your final medical expenses too. Most people pass away in a hospital, or they pass away at home and are on the way to the hospital. There's ambulance fees, there's doctor's fees, there's hospital fees, whatever. Funeral costs and medical costs must be paid first out of the estate. That's the first thing that needs to be paid under state law. After that, you pay all your other debts, like Mufti Abrar mentioned, all your other debts. In Illinois, what are those debts? First debts are your taxes. You pay your probate taxes, if they're relevant. You also have to pay your income taxes. Because suppose you pass away in July, and you work from January to July, and you earn your income from January to July. You're still going to tax you for that. So your not your heirs, but your executor, the person you assigned to take care of it, has to take money out of your estate to pay your income taxes. You have to pay any debts that you have also. First debts you pay are your secured debts, which are going to be mortgages and if you have car loans, anything that we have collateral. Okay, cars and houses are usually what people have. Those have to be paid first. Now you have to look at, well, whose name is on the mortgage or the note, and is your wife going to be responsible? If it's a joint note, is your wife going to be responsible? How's it going to work? There's a lot of questions there. But that's the first thing that needs to be paid, or after tax, the second thing that needs to be paid is your secured debts. After that is your unsecured debts, which are credit cards, personal loans. That's usually credit cards, personal loans, lines of credit with, like, you know, if you have like a line of credit with Best Buy or Home Depot or something like that, those need to be paid. Those have the lowest priority. Usually what happens is that if you have, well, most people are worried about, okay, their credit cards, because, you know, the house, they're worried about that. But then think about, okay, well, if I have credit card bills and lines of credit, stuff like that, what happens to that? Most often when you pass away, the first thing that you need to do, your heirs need to do, or if somebody you know passed away, the first thing that needs to be done is to call those credit card companies and tell them the person has passed away, because they'll freeze the interest rates right there. And they won't add anything more on for interest, so at least it's not going to keep growing, it'll stop right there. And then what you do is negotiate with them. And if it's, usually they'll discount it if somebody passes away. So if you owe, say, $1,000, they'll say, just give us $700 or $800 or something like that, and you're able to negotiate with them to lower the debt. After that, then we start opening it up and taking a look. We look at the wasiyah. And what Mufti Abrar mentioned, if you had any specific things that you wanted to give to anybody, your charity, or to, you know, the needy family member, or their family members, or something like that, you take care of your hukuk law, like if you have unmissed prayers or fast or something like that. You take care of all of that out of 1/3. If once you have taken care of that, then we go into the mirah, and that's how it works here also. That's how it works in the courts. Courts are going to take a long time though. Minimum time in Cook or DuPage County is about a year. Cook County is a little bit longer. It's usually about 18 months. That's the minimum time. Usually it goes longer, but that's the minimum time that it takes. There are ways to avoid going to court and still making sure everything is distributed in the same way. First, all your debts are paid, and then the taxes, and then all your other debts, and then you can do it all the same. You can do all of it correctly according to Sharia without going to court also. And this is what we do when we create a trust. And that's something that, you know, people talk about, okay, well, I want a trust or revocable trust or a living trust. What is that? That's what this is. A living trust is a means to avoid going to court and still get all of your distribution done. Brief thing, what a trust is. The way a trust works is you have to have something. A dollar, a pen, there has to be some asset. Once you have that asset, you have, first person is me, I'm the grantor. I own it, I give it to someone. So I give it to, say, Mufti Abrar, he's my trustee. Now, it's his responsibility to manage the asset. And he manages it for whose benefit? He manages it for somebody's benefit. He has to use my pen for someone. And we'll say that someone is the HR. Now I've created a trust because I'm a grantor. I give something to a trustee to use for someone else as a beneficiary. This is a trust system. Now, in a revocable trust, what you do is say, I take my pen and I give my pen to myself as a trustee for my benefit as a beneficiary. Now, technically, I haven't done anything because I saw that I could use my pen. It's all like right there. It's sort of like a legal fiction. But in reality, what I've done is I've created a trust. So if I pass away as a trustee, I can assign somebody else to be my successor trustee. And if I pass away as a beneficiary, I can assign someone else to be my successor beneficiary. So if I have the asset, now the asset, I say I have it myself, I assign Mufti Abrar as my trustee, now he automatically takes it and he doesn't have to go to court to prove it. And I've listed my beneficiaries, my wife and my children, then Mufti Abrar can use my assets for them, and you don't have to go to court. And that's what we do to avoid going to court by creating a trust. And then in the trust, you write down what you want to do in Sharia, what you want to do to distribute your assets. So that's how we get around going to court. The next issue is disability. Most people don't die suddenly. Some people do, most don't. Most people have a sort of prolonged period where they're ill, where they're sick, they're in and out of the hospital for a while, maybe 5 months, 6 months, years, sometimes longer. During that period, it's important to have people designated who's going to make decisions on your behalf. Who's going to talk to the banks, who's going to make financial decisions, who's going to sell property, who's going to close accounts, do all this, who's going to talk to doctors, who's going to release medical records, who's going to consent for surgeries, who's going to know what surgeries to consent for and not to consent for, etc. You have to have these people spelled out. Because you don't want to mess. If you're in the hospital, you don't want your children fighting over what to do or what not to do. You designate somebody, you say you're in charge, you make the decision. Now, most people have their spouse and then their children do it, but some people have said, like, you know what, I don't want my children to do it, or say, like, you know what, my daughter's a little bit too emotional, I don't want her making this decision, I'd rather have my son or my cousin or my brother or somebody else make that decision. It doesn't matter, the important thing is that you have somebody there who will make the decisions. Okay, now this is the important thing, like we're talking about, well, we want to know how to do things, how to distribute along Sharia, how to distribute by Sharia, how to actually get the assets to my heirs, but you also have to assign the right people to do it. And you have to let them know that they have to do it. This is a funny story. When I was in law school, one of my professors came to class, I think he was about 10 or 15 minutes late. I asked him why he was late, and he said, well, his neighbor passed away. And his neighbor had a 14, 15-year-old daughter, and in his neighbor's will, he left the daughter to him as a neighbor. And he was astonished by this because he was one of those neighbors that you just wave at when you're mowing the lawn, and you just walk by, say hi once in a while. Maybe they exchanged gifts at like Christmas time or whatever, but he barely knew him. He left him his daughter as and so he's like, I already had 3 teenagers and now I have a 4th. I don't know what to do. Like, that's why he's late. And so it's important, it's a funny story, but it's important that when you assign somebody, they know what their responsibilities are, they know what they're taking on, or at least they know that they have their name in the will. And you choose those people carefully and you choose them in the right order. So we're not just talking about, okay, well, this is how I want to distribute it, but you're gone. You need to assign somebody to distribute it. And if they can't do it, who will do it? If they can't do it, who will do it? Usually I recommend 3. But it's important to have all of these people listed. They know what to do, and they know what decisions you want. If you want, Mufti Abrar talking about, if you're on a ventilator, the doctors agree, somebody has to make that decision. You can't make that decision anymore. You have to assign somebody to make that decision for you when that time comes. The final issue that I just want to briefly mention, because it's not applicable to everybody, is liability. And this goes a little bit beyond the scope of estate planning, because we're talking about not just planning at death, but planning during life also. A lot of people have either a high-risk profession, like doctor or a lawyer or something, where you have risk of malpractice, or you have high-risk investments. High-risk investment is that people have, say, businesses or gas stations or a lot of rental properties, something like that. When you have a lot of that, there is a risk that if somebody sues you, all your properties can be affected, which of your properties can be affected, and you're going to lose your personal assets. So when we talk about estate planning, we're talking about at death, but we also need to plan at death how you hold your assets during your life to give you the maximum amount of protection from the unforeseen in this circumstance. But if something happens, if you get a lawsuit, either as a professional or as an investor, how do you protect your assets? I don't want to spend too much time on this. If you have questions, we can talk about it privately, because I don't want to but some people don't have that issue. So this is just my personal information. If you want to email me about it, if you have any questions you want to email, I know Mufti Abrar and I are also going to take a few minutes to answer your questions that you may have. But in summary, what we both talked about is, first, what does Sharia require of us? And it requires a certain thing when we pass away. How to give our assets, how to behave, how to act, how to think about things. And then this country has its defaults. Like, it has its own rules that, okay, if you die, this is what's going to happen. And what we want to do is bridge the two. We want to bridge it from what we know is going to happen if we die to what we want to happen when we pass away, to abide by Sharia. And the process of estate planning is actually building the instruments, building the documents to bridge these two things, to make sure that we are in compliance with Illinois law, that we're doing everything by the book, but we're also doing everything by the Quran. So now we're also doing everything by that book. So